Patent strategies for corporate product marketers. This presentation outlines a range of patent strategies available to corporations involved in the manufacturing or marketing of products for the US market. The threat of patent infringement litigation hangs over anyone actively making, selling, or using products that incorporate recent inventions. Patent infringement lawsuits can come from patent holders that are competing in the market. But many suits today are brought by specialist patent assertion firms that don't make or sell their own products. If you're found to infringe patents held by another, the court can assess a reasonable royalty that you will be forced to pay to the patent holder. These awards can reach hundreds of millions of dollars and can be multiplied by a factor of 3 if the infringement was knowing rather than accidental. To prevent future infringement, the court can issue an injunction preventing future sales of products containing the patented invention. This can have the effect of shutting down entire business operations. In view of the size of awards that you may face in court and the millions of dollars you will face in legal fees, it's often preferable to settle with the patent holder out of court. This can still involve the payment of 7-figure license fees. Patent-related threats facing product companies are significant and justify a proactive patent and IP strategy. One of the most important patent strategy objectives is to provide the company with freedom of operation, the ability to make and sell products without infringing patents held by others. To make this possible, the company's patent portfolio should mirror and support the product range. However, the product range evolves and changes over time, and the patent strategy needs to allow the company to move into new markets, launching new products. The patent portfolio is often playing catch-up with the product portfolio in fast-moving industry sectors. The patent strategy has to be designed to minimize the risk and cost of patent infringement litigation. Of course, the best way of achieving this is to avoid infringement by owning the patents covering all the inventions embedded in the company's product range. This is highly desirable, but not always achievable. Patents are actively traded today, and large patent holders are beginning to realize that maximizing the revenue from pruning their portfolios, selling redundant patents, is an important corporate priority, as these revenues drop directly to the corporation's bottom line. Clearly, one of the key objectives of a corporate intellectual property department is to prevent the company infringing patents held by others. There are several activities necessary to achieve this. The product portfolio must be supported by patents. This requires a high degree of synchronization and effective communication between the intellectual property group and the product development group. As well as owning patents to inventions incorporated in the company's products, infringement can be prevented by licensing patents held by others. The negotiation of cross-licenses is an effective method of gaining access to large pools of patents owned by other companies. Actively acquiring dangerous patents when they come onto the market can take these weapons out of the hands of potential litigators. The cost of acquiring a patent today can be very low when compared with the cost of defending an infringement suit tomorrow. Operating in stealth mode, staying under the radar, can help a company avoid becoming the target of patent lawsuits. For the world's largest technology corporations with very high profiles, it's virtually impossible to hide from potential patent litigators. However, even these companies can minimize their risk by keeping their patent trading and strategic activities carefully contained. Building a strong portfolio by creating new inventions in-house, filing and prosecuting new patents, is the primary activity of many intellectual property groups in large corporations. Employees are incented to create new inventions, and the resulting patents are assigned to the company. As there's a current backlog at the patent office, the prosecution process that converts an application to a granted patent takes anywhere between 2 and 7 years, depending on the type of technology and the number of examiners currently available in the field. The cost of prosecution is usually somewhere between $10,000 and $40,000 for a single US patent, depending on which patent attorneys are used and how much discussion takes place between the attorney and the examiner. A US patent provides protection only within the US market, so separate patent applications have to be made for each country in which the product operates and wishes to retain exclusive rights to their inventions. The cost of prosecuting an international family of patents can easily run into 6 figures. When filing a new patent application, there's always some degree of speculation as to whether the claims are going to be allowed and the patent ultimately granted. The patent laws are changing. Many believe the bar is getting higher and that fewer patent applications will be granted in the coming years. Patents are increasingly being traded on the market. They're sold by independent inventors, failed startups, successful startups, and corporations divesting of redundant patents following a change of direction or some form of management shake-up. A patent that's of little use to one company could be highly desirable to another. Many of the most dangerous and valuable patents are traded and sold to the highest bidders. The process of buying patents takes 3 to 9 months. The first phase is spent defining the priority areas, searching the market and identifying key patents of interest. The next phase involves negotiating a price, and the final phase involves drawing up the patent purchase agreements and conducting due diligence. Pricing depends on the market sector, the breadth of the patent claims, the number of competing buyers, and evidence of potential infringement. Most patents sell for somewhere between $50,000 and $150,000. Exceptional patents can sell for over $1 million, but this is highly unusual. Working with brokers, agents, and an online exchange like Tynax, the buying activity can be undertaken in stealth mode. The fact that the company is searching and what you're looking for is sensitive information and can be kept confidential throughout the process. Changes in corporate strategy often render patents and groups of patents redundant. When the company decides to move out of a particular business or product line, patents in that field are no longer necessary to support the company's operations, and they can be sold at a profit. As patents often sell for $50,000 to $100,000 each, the resulting revenues are often welcome additions to the corporation's quarterly bottom line results. A company that fails to prune its portfolio on a regular basis will find itself paying unnecessary maintenance fees to the patent office, as well as leaving money on the table. A license back can be incorporated into the patent sale transaction, so the company is able to continue practicing the inventions and marketing its own products incorporating the patented inventions without fear of infringement litigation from the buyer. A cross-license is an agreement between 2 corporate patent holders to pool or share their patent portfolios. The objective is usually to prevent expensive infringement litigation between the parties and to defend against potential litigation from other patent holders. Often no money changes hands, and the arrangement is simply a covenant not to sue each other. Cross-licensing is common in some industries and effectively reduces the threat of litigation. Corporations are increasingly buying memberships in patent pools. By doing so, they effectively license a large number of patents in a single transaction. The number of pools and the number of patents they own is growing. Some patent pools are known to the public and have been featured in the press, but many operate in stealth mode, keeping their activities confidential from all but their members. When your patents are being infringed by competitors or anyone operating in the market, you have a right to assert them through litigation in the federal courts. If your company employs armies of patent litigation attorneys, you may be in a position to bring lawsuits without hiring outside counsel. Your legal team would be responsible for identifying potential infringers, gathering evidence of infringement, and preparing the court filings. As this is a very distracting and time-consuming process for in-house lawyers, patent infringement suits are usually handled by specialist outside law firms. These suits are often covered by the press and can affect the corporation's brand image, so press relations must be considered in conjunction with these activities. Specialist patent litigation firms often waive hourly fees and work for plaintiff patent holders on a contingency basis. The company still pays the court filing fees, witness costs, and out-of-pocket expenses, but you can expect the law firm to take somewhere between a third and a half of the monies recovered from infringers. Some specialist patent assertion law firms are prepared to cover all the costs of bringing lawsuits against infringers. Essentially, the company assigns the rights to enforce the patents to the litigation firm. The patent litigator's right to assert on behalf of the patent holder are established by contract. This is not a traditional client-attorney relationship, as the client is unable to fire the attorney. The arrangement involves a revenue share where the patent holder and the litigation firm share the proceeds from court awards and licensing settlements. A potential infringer has a very compelling reason to pay license fees when faced with a credible threat of enforcement. The threat is very clear. If you don't license our patents, we'll sue you for infringement. In some cases, the lawsuit is filed before the licensing discussions are initiated. At the very least, lawsuits and threats can be effective means of grabbing the attention of potential licensees. Enforcement-based licensing to infringers has been a profitable activity for many patent holders. However, lawsuits can be expensive and persistent threats can harm the image of the company. So this type of activity is practiced by specialist licensing firms and smaller corporations with little to lose. Licensing your patents doesn't have to be a threatening or adversarial activity. Friendly licensing is the theme for many large corporations, universities and research labs. IBM is reputed to generate more than $1 billion a year from outbound licensing. However, IBM is the largest patent holder in the world, employs a large licensing team, and has been known to sue infringers in the past. So IBM clients do have compelling reasons to pay license fees. Without a credible threat of patent enforcement, it's not easy to convince infringers that they should pay a license fee. So friendly licensing is usually based on providing new technologies and abilities that licensees don't currently enjoy. By paying a royalty for access to new technology, the licensee is enabled to build new products and capabilities. Exclusivity is another reason for buying a license. Many of these technology-oriented license arrangements involve exclusive rights to certain markets and fields of use. Licensing officers are sometimes surprised when their friendly approaches to potential licensees result in letters from lawyers or even lawsuits. A potential licensee, in fear of a possible future infringement action, has a right to strike first, bringing a lawsuit that asks the court to remove a cloud of uncertainty by making a declaratory judgment that the company is not an infringer of the patents in question. Friendly calls to licensees can sometimes result in hostile responses. The friendly approach can work well when licensing trade secrets, but can be ineffective when licensing patents that carry an inherent threat of enforcement. Patent strategies for large corporations today involve much more than prosecuting new patent applications. Proactive intellectual property groups are increasingly trading in the marketplace, acquiring new patents, and selling off redundant assets. In licensing, via patent pool participation and cross-licensing arrangements, can rapidly extend the corporation's patent coverage, adding hundreds, even thousands of patents to the available portfolio. Out-licensing can generate additional revenues, especially when accompanied by a credible threat of litigation. Enforcement against infringers is an activity that can be outsourced today to specialist litigation and licensing firms. Modern intellectual property groups are developing the capability to buy, sell, license, partner, and respond rapidly to the changing needs of the corporation.